So Section 17A of the Prevention of the Corruption Act is once again in the news. There's a split judgment that has come in from the Supreme Court of India. Your thoughts on what the judgment has said, especially the views of Justice Nagarathna?
17A has a little bit of a history. Initially there was 6A, which gave protection to public servants above Joint Secretary and above. And that was struck down by the Supreme Court more on the basis of classification, that how can you classify public servants into two categories and give protection to only some of them and not to the others. And then 17A was brought in, which is now a protection to all public servants, that no investigation can be done without prior permission of the government. I think the view taken by Justice Nagarathna is the correct view, because what Justice Vishwanathan has done has literally gone to legislate while interpreting, which is definitely not the role of the court. He has gone to say what should be done also, rather than simply looking at whether the law is correct or not. In my view, 17A should clearly go, because when a bureaucrat, most of the time when he indulges in corruption, he does it mostly to please his political bosses. And if this 17A remains on the statute book, the chances of the government not accepting that investigation should be done will result in very genuine cases not being registered and not being investigated. Now the difficulty, and in any case bureaucrats have the protection under 19, so they have that sanction requirement under 19. Bureaucrats already have the protection of sanction, that a sanction is required before the cognizance is taken. Now, to give this additional safeguard for the purposes of investigation will in most cases result in proper investigation or proper material being lost, which is the need of the hour whenever a criminal case is registered or there is a cognizable offence committed. And the investigation, if it is not done immediately, because sanction comes much later. Sanction comes at a stage when the investigation is over and the police asks for sanction at the stage of filing of the charge sheet. In this case, if the investigation is stalled, then the purpose of identifying who is indulging in corruption and what kind of corruption is being done, that will be completely lost. And in my view, this protection in 17A was of course akin to 6A, and the very fact that there is no classification amongst public servant is no ground to say that 17A should remain in the statute book. There is enough safeguard at the stage of sanction, and in most of these cases where false cases are registered and where a public servant is made to suffer a criminal case for doing something which according to him was right, then courts in writ jurisdiction have come to the rescue of bureaucrats, and that avenue is always open to a bureaucrat. To say that bureaucrats would stop functioning or it will be a dampener in their ability to take a bold decision, in my view, is a complete misreading of the intent behind providing this kind of a protection from starting an investigation. And I'm sure and I'm quite hopeful that the larger bench, whenever this considers the view, will definitely strike down 17A as being unconstitutional, because for the purposes of investigation, nobody has any right to say that a case should not be investigated if the allegation of a cognizable offence has been made out. Now, Prevention of Corruption Act is different from an IPC corruption in any ways, or in an IPC offence in any case. In an IPC offence, you can register a case merely by saying that a cognizable offence has been committed without even naming the accused. Whereas the Prevention of Corruption Act, fortunately, no case can be registered without naming the public servant. There has to be a public servant involved who has to be indulging in corruption for the purposes of registering a case under the Prevention of Corruption Act. Now, with the twin requirement already there in the statute of firstly identifying a public servant who has indulged in corruption, and secondly that public servant indulging in a cognizable offence, I think that itself is a protection to the public servant, because identification in such matters is also a difficult task at the stage of registering a case. So the moment you have to register a case and specifically allege that this public servant has committed this particular offence for the purposes of being prosecuted under the Prevention of Corruption Act, I think that also is in some sense is a safeguard. And if he is not indulge in that activity, he can always, if he is completely in the clean, he can always go to the writ court and say that a matter which is in the routine taken by him is being subjected to criminal jurisdiction because offence also should have been committed by him. It's not merely having taken an action is sufficient for the purposes of the Prevention of Corruption Act. So I think this judgment definitely, now that it will go to a larger bench, this section 17A in my view should be struck down because it is completely arbitrary and it is unnecessary, giving an additional protection to public servant when they already have a protection in the form of sanction under section 19.